Uh, Welcome back to the JDG. This is our fifth meeting in Hillary term, and we are joined today by Professor Hilary Nye, who is an associate professor at the University of Alberta. Hilary, thank you very much for joining us here today. We really look forward to your presentation, and the floor is yours.
Thank you. Assistant professor for now, but thanks. Yes, so good morning, everyone. Well, morning for me. I think it's evening for you. So sort of a strange world that we're all in, but I'm grateful to be able to present from a distance. So thank you very much for having me here, and thank you all for joining us. So what I'm trying to do in this paper is to engage with hypotheticals that we're familiar with from philosophy, right? We've seen all of these really wild or out there hypotheticals that get used, and where kind of an unusual example will be used, and then a conclusion is meant to be drawn to do with something that's more related to humans. So we'll use something like an angel or a crab, but then try to draw a conclusion about a human being. And so these kind of wild hypotheticals, I think there are big questions about how they're used. And there is already good work done raising criticisms of those kinds of hypotheticals, some of that in legal philosophy and some in philosophy more broadly. And so I'm not doing quite that project of critiquing whether they can tell us anything at all, though I do have some skepticism about that issue. I have some concerns about what exactly we can draw from really wild hypotheticals for conclusions about human society. But for this particular paper, I'm interested in a more specific question, which has to do with the role that those hypotheticals play for certain major people in legal philosophy. So in particular, what is it that these hypotheticals can tell us, or the use of these hypotheticals can tell us about the methodology of the people employing them? So what are they doing with them, and how does that work? So I look at three examples in the paper that all use these kind of strange non-human creatures and then try to draw a conclusion about human law. So just briefly, I'll talk about each and then I'll go into each of them in more depth. But in Hart's case, the famous example is the one about people having a crab-like carapace, so a hard shell that protects them from attack. And I have to say, it's such a delightful example. It might be half of the reason I wrote the paper in the first place, was just to get to write about this really crazy story about people becoming sort of crab-human hybrids. So it's really kind of delightful little story. Where we imagine that they have these hard shells and also that they're able to gain sustenance from the air. So that's the Hart example. Again, I'll talk a little more about it later on. And then in Raz's case, we have the famous angels example, which has also gotten a lot of attention in legal philosophy. And so the question is really, can there be law in a society of angels? And if so, would it have sanctions? Because we know that angels are well motivated, so would they need sanctions? We then have Shapiro, who tries to use the example of an alien society and asks whether alien societies have law, and argues that in some sense, as long as the beings are rational and they build a system that's meant to guide their behavior, that in some sense is going to count as a legal system. So we're dealing with these kind of three wild creatures: crabs, angels, and aliens. And I want to know, what is it that people are doing with these examples? What are they trying to draw out? What do they take to be possible to learn from these examples for law? I'm going to focus in the presentation just on Raz and Hart, partly because I think Shapiro's is really easily assimilated to Raz's. I think they're engaged in the same methodology, so I'm not going to talk about the aliens so much. So I'm going to start with Raz. So a lot has been written on this, and again, my purpose here is slightly different. So in the paper, I talk a little bit about some of the people who raise critiques of this argument. So Ken Hima, Dan Priel, Andre Marmor, and then there's a recent, or I think still forthcoming, piece by Lucas Miato that engages in these criticisms really helpfully. So those criticisms exist, and as I say, note them in the paper, but I'm doing something a little bit different here. So just to get the argument on the table, the angels example kind of runs as follows. So we imagine a fictional scenario. We imagine a community of angels. And of course, we know certain things about angels, just sort of by definition of the kind of creatures they are. We know that they're well motivated. They want to do the right thing. They're good fundamentally. So we know that they're going to be inclined to do what's right. And so given that information about angels, we then reflect on kind of how their society would be structured, given the kinds of beings that they are. So they need law to help them solve coordination problems, like what side of the road to drive on. They need law to set like an optimal tax rate, for instance, but they won't need it to tell them to obey because they already have the motivation to obey. So once those matters are settled, the idea is they won't need sanctions in order to force them to obey. So that much, it seems to follow fairly straightforwardly from the setup of the thought experiment, just by virtue of the kind of beings that angels are. But it's the next step that I'm going to focus on, which I think is the more controversial one. And that is, we conclude that since angels don't need sanctions in their law, therefore sanctions aren't a necessary feature of law. So we move from a claim about the angel society to a claim about something to do with law's nature. And this appears to rely on an intuition that's supposed to be drawn out through the thought experiment. So in imagining the angel society, we're supposed to share the intuition that the angels have law. So the system that they have is a legal system. And if we do share that intuition, then the conclusion is supposed to follow for this thing called law. If their system is a legal one and it doesn't have sanctions, then we know that it's not sanctions are not a necessary feature of law. So we've therefore used the angels experiment to tell us something. We've learned something new about the nature of law. So this kind of approach uses a thought experiment to tell us about a possible world. And I think this approach makes sense if we're engaged in an analysis of the nature of law, because the nature of law is understood, an analysis of the nature of law is understood as a search for its metaphysically necessary features. And that's sometimes glossed as the features that it has in all possible worlds, right? So then it makes sense to look at a possible world that includes angels or a possible world that includes aliens in order to examine what law's traits would be in those possible worlds. And then we can move from that thought experiment to a conclusion about the metaphysical nature of law. And I think this kind of search for metaphysical necessity seems to be more widespread in legal philosophy these days. It seems to be becoming more so. And I think, without engaging in the question of who all exactly is doing this project, I do think it's right to say that Raz is endorsing this kind of methodology. He seems to be aiming at getting, making claims about the nature of law. And he says he's seeking claims that are necessarily true and that explain what the law is. So I think Raz is engaged in this metaphysical project. He's trying to explain the nature of law, and the angel's thought experiment is one piece of that, right? He's using this kind of thought experiment to tell us something about law in all possible worlds. So turning then to Hart's thought experiment, he again uses this example of crabs, and I'm just going to quote from him here because I don't think it's possible to say it better than he does. He says, suppose that people were to become invulnerable to attack by each other, were clad perhaps like giant land crabs with an impenetrable carapace, and could extract the food they needed from the air by some internal chemical process. So this thought experiment, besides its obvious entertainment value, I think has a lot of value in telling us about Hart's methodology. So the question that I'm going to answer then is, how is he using this thought experiment? And is that different from how Raz is using it? So we're asked to picture this world in which humans have traits that are very different from the traits that they have in our actual world. So they've got these impenetrable shells that protect them from violence. They're able to get sustenance from the air, which means that the necessities of life are unlimited, and so we don't need to be in competition for them, right? We're all able to get enough to survive. And so these two facts will lead to two conclusions. Hart says the crab creatures wouldn't need laws against violence because of their protective shells, and they wouldn't need a system of private property, or to the extent that they have a system of private property, it may look quite different than the one that we have. because essentially there's enough for all without the protection of private property. And so up to this point, Raz's thought experiment and Hart's thought experiment look very similar. So the structure is the same. So the absence of a need for rules against violence, rules protecting property, that follows directly from the traits of the human crab hybrid, right? Because of the kind of beings they are, this is the conclusion we reach about the society. And just the same in Raz's version, the absence of a need for sanctions follows directly from the traits of the angels. So we've got, beings that have particular traits, and the claims about what the society is going to look like kind of follow directly from those traits. So the question for me then is, what happens next? What do each of them do with those claims? And I think this is where the big difference comes. So Raz concludes that since there's a possible world in which the law lacks sanctions, then it's necessarily true that law need not have sanctions. But Hart doesn't draw a similar conclusion about the rules against violence or theft being not necessary for law. In fact, he reaches almost the opposite conclusion. So he uses the example to show us just how important rules about murder, assault, and private property and so on are to us. So I think that seems to demonstrate the biggest difference, right? Hart is making an argument about in what sense these rules are important and even necessary, but he doesn't mean to invoke metaphysical necessity. So instead, he's talking about what he calls natural necessity. And I'm going to spend a little bit of time trying to understand what he means by that. So natural necessity is the term that Hart gives to things that are necessary given certain features of the world and features of human beings. And so these various features of the world and of people, he says that they're contingent, but they're essentially, even though they're in some sense contingent, they're really unlikely to change or unlikely to change with any speed. So he looks at these relevant features of human beings and of the world, and he tries to point to those to give us an account of what human law is like. So what is law like because of the beings that we are? And so that's natural necessity for Hart. So I'm going to quote from him so we have a clear idea of his definition. He says it's a term for the category of statements, the truth of which is contingent on human beings and the world they live in, retaining the salient characteristics which they have. So Hart's concept of natural necessity is a kind of necessity that's tied to our experience of the world. The conclusions we can draw from examples of this sort are conclusions about law's features given the kinds of beings that we are, not conclusions about law's features in all possible worlds. So in the paper, I map that idea of natural necessity onto some discussions of necessity in philosophy more broadly. In particular, Kit Fine has an article on the various types of necessity that exist. And one of the types that he mentions is what he calls natural necessity. It's also sometimes called gnomic necessity. So I'm going to refer to those, use those terms interchangeably in what follows. But the important point Fine makes is that natural or gnomic necessity is fundamentally distinct from metaphysical necessity. So I'm going to quote here from Fine too, just so we have his idea of natural necessity on the table, then we can see if it's the same thing that Hart is talking about. So Fine says natural necessity is the form of necessity that pertains to natural phenomena. Suppose that one billiard ball hits another, we're then inclined to think that it's no mere accident that the second billiard ball moves. Given certain antecedent conditions and given the movement of the first ball, the second ball must move. And the must here is the must of natural necessity. So according to Fine, natural or gnomic necessity is necessity having to do with the laws of our universe as it actually is. So having the particular gravity that it does, having the physics that it does. So he's not talking about necessity, the necessity of all possible worlds, like metaphysical necessity. It's necessity according to the laws of our world. So the billiard ball will always move in the way that it does in our world because of the physics that we have. So then my question is whether this is what Hart was getting at when he talked about natural necessity. And we might think so. Hart refers to facts about our biology and our psychology, and he says those facts make it the case that in human societies, we'll always find systems of law that contain these same kinds of prohibitions on assault or protections of property, etc. On the other hand, we might think that those kinds of facts are not quite the same as the physical facts about the movement of the billiard ball. So facts about human nature and biology and psychology tend to entail more variations. There's more variation among human beings, and their claims about human nature might be more contentious than claims about physics. So in the way that we're really certain the billiard ball is going to move and move in the exact way that we know it's going to move, it seems less clear that we can say when it comes to legal systems, we're necessarily sure that these kinds of systems will always be created given the traits that we have. I think we might say something closer to, given the prevalence of these traits among humans, it's highly likely that we'll find a system with these attributes. So that's actually something that I'm open to feedback on. I think there is an argument that Hart is talking about natural or gnomic necessity in the same way that that Fine is, but it's also something that I think he could be doing something slightly different. So I'd be open to hearing people's thoughts on that as I'm still sort of working through these ideas. But I also don't think it's entirely necessary to settle this question, because my main claim is simply that Hart wasn't making a claim of metaphysical necessity, sorry. So I can actually remain agnostic about whether he's talking about natural or gnomic necessity, or whether he's talking about something even weaker and just saying, look, societies like this will often come into being. So either of those claims is still going to be different and weaker than the claim of metaphysical necessity. So that's the key point I'm making here, is just that he's not making a claim of metaphysical necessity. So when he says that if humans were like crabs, their law would lack rules against violence and rules protecting private property, he doesn't go on to make that next step that Raz does and say, well, their system would be a legal system, and therefore that tells us something about what law in its nature is like. Instead, he makes a conclusion, he draws a conclusion about the human dimensions of the phenomenon we're interested in. So we have to be attentive to these features that humans have, their vulnerability to attack, features of the world, such as scarcity of food. We have to pay attention to these to make claims about law, but we're making claims about law given the world that we live in. And that's a very different kind of conclusion than the one that Raz and Shapiro were trying to draw from their hypothetical societies. So just as a clarification, I'm not arguing that this is a distinction in the thought experiments per se. So it's not as though thinking about angels will always get us necessary truths and thinking about crabs can't. It's more about what they're actually doing with the examples. So Hart could have used the crab example to tell us something about what law is necessarily like. So if we were going to do that, we could run through the thought experiment in the same way that Raz does. So we imagine this society and it lacks rules against violence and theft. And then we just ask ourselves, do we have the intuition that this is a legal system? And if we do share that intuition, then I think we would draw the conclusion that therefore we've learned something about law's nature, that is that it doesn't require these kinds of prohibitions. So Hart's not doing that though, and that's the crucial point. He could have, but my point is really to draw attention to what it is these thought experiments are actually used for by these theorists. And in particular, what I'm trying to do is suggest that the use of these thought experiments shows us a really important difference in orientation between some of the main positivist thinkers. So where I think a lot of people take Raz and Shapiro to be following in Hart's footsteps and carrying on the same kind of project, I actually think their view represents very much a shift to a different metaphysical approach. So in the paper, I kind of further support that claim with some arguments about Hart's methodology. I'm not going to spend as much time here today in going into those claims, but in the paper I spend some time trying to parse the various things he says about his methodology, because I think there's some ambiguity there. It's not always entirely clear what he's up to. But in the paper, I try to argue that there is an interpretation of Hart according to which he's not doing the metaphysical project. So I don't try to rest all of that just on the Crabbe's thought experiment. I try to show that that in the other parts of his methodology, in other parts of his work, we could also see those as compatible with the non-metaphysical methodology. Again, I can pick that up in the questions if that's something people are interested in, but I won't go through sort of my various interpretations of what he's up to. So instead, I just want to talk a little bit about this kind of turn towards metaphysics. So if Hart wasn't doing it, sort of when did it come about, and what should we make of it? So if it's true that Hart's discussion of the Crabbe example was never intended to illuminate truths of metaphysical necessity, then we kind of have to wonder, where did this come from, and how, when did this shift occur? And in my mind, the shift occurs more with Raz. So in the modern landscape of legal philosophy, it's people like Raz who are making these strong necessity claims about law. And to kind of unpack this further, I want to talk about the difference between inclusive and exclusive positivism. So I think the methodological difference kind of maps on, interestingly, to the difference between inclusive and exclusive positivism. So Hart's inclusive positivism, I think, makes sense with the interpretation that I've given of his methodology, where he's not doing a metaphysical project, because that form of inclusive positivism is not making a claim about the way things are. It's actually just denying a necessity claim. So it might seem that inclusive and exclusive positivism aren't even really on the same territory. So exclusive positivism is trying to make metaphysical necessity claims, whereas inclusive positivism is only in the business of denying them. So that is at least Hart's version of inclusive positivism. I think there may be other inclusive positivists who frame it as a claim about the nature of law. But Hart's major claim was to argue that there's no necessary connection between law and morality, right? And that's a negative claim. He's basically denying a necessity claim, whereas with Raz, he's making a necessity claim. He's saying it's a necessary feature of law that it does not exhibit the particular connection to morality that he's concerned with, whereas Hart is denying a necessary connection. So you could be, the denial of a necessary connection is compatible with the metaphysically weaker claim that there's no necessary connection between law and morality because there are no necessary features of law at all. So the pure denial of a necessity claim could be just part of a view that doesn't take itself to be searching for necessary features of law at all, like the version that the interpretation that I've given to Hart's thought. So if he's not doing metaphysical claims, this idea that law and morality don't have a necessary connection could still fit with that idea that there's no necessary connection because we're not searching for metaphysically necessary connections. Whereas Raz is trying to give an account of what law is necessarily like, which involves more robust claims about its nature. So the point of this elaboration of the difference between inclusive and exclusive positivism is just to say that I think we can plausibly interpret Hart as not giving an account of metaphysical necessity or making claims about metaphysical necessity. I think the kinds of claims that he makes, his broader claims about law, that it's a matter of the union of primary and secondary rules, the presence of a rule of recognition, and all of this, I think can be understood not as claims about its metaphysical nature, but just as kind of non-metaphysical articulations of the kind of thing law is, given the kind of beings that we are. And so, in other words, we can interpret Hart as talking about gnomic necessity rather than about metaphysical necessity. So I think this is the better interpretation of Hart, is that he's not doing the kind of essentialist analysis of law that many of the people who followed him, such as Raz, are engaged in. And of course, the paper's not doing historical analysis, so I'm not really trying to say that it's that one thing caused another, or here's why this shift happened. I don't have an explanation for exactly when or why the shift towards metaphysics happened. And I'm open to other stories about why this might have occurred, but it does seem to me that at least Hart wasn't doing it, and it seems that Raz is. And so this shift to the metaphysical project must have occurred at some point after Hart. Okay, so just to close, I want to just talk a little bit about if Hart isn't doing this metaphysical project, then what is it that he's doing, and is it plausible? Is it something we should endorse? So if we're moving away from the metaphysical approach, then we're saying we're not aiming to figure out what properly counts as law. We're not interested in discovering the boundaries of the phenomenon and giving the correct account of what counts as law. We're looking instead, as I've said, to gnomic necessity and talking about what is law like given the human traits that we share. But I think a question that might arise at this point is, in order to engage in this discussion, don't we still need an account of what we mean by law, right? So in other words, in order to talk about the traits that law has because of the beings it serves, so in order to talk about the gnomic necessity claims that I want to make about law, don't we have to first identify the phenomenon we mean by law? And so you might think we can't escape this metaphysical debate. So we need to answer sort of what is the thing whose traits we are examining? And it's that fundamental question, what is that thing, what counts as law, that occupies the people who want to answer the metaphysical question. And I take it that those who want to do gnomic necessity kind of analysis are not engaged with that account of the true nature of law, because that would be to shift over to discussions of metaphysical necessity. So they're not interested in drawing the correct account of the boundaries of law, trying to understand what counts as law and what doesn't. So in order then to discuss the gnomically necessary traits of law, we would need some kind of starting point, some kind of account of the thing that we're calling law for the sake of inquiry into its gnomically necessary traits. So I think that this is possible sort of partly by stipulation. So we kind of can spell out a concept and clarify what we take it to include and use that as a platform for further investigations into what is gnomically necessary about that practice. So we can use these kind of natural necessity arguments to say that, you know, humans, given their characteristics, will create certain kinds of institutions. They'll tend to have courts and legislatures and so on. And then we can set out a concept that includes those institutions, but we don't engage in further debate about whether that concept properly tracks the nature of law, because that would be then to step into the metaphysical debate. So I think it's possible to spell out an account of what we mean by law without saying that it's necessarily the correct account metaphysically. So I guess the final question then is, why should we choose an approach like this instead of the metaphysical one? So even if I'm right that this is what Hart was doing, is there a reason to side with Hart over Raz on this methodological question? And for me, the question comes down to what can be gained from finding out any truths about a phenomenon as broad as one that includes angels and aliens. So does it benefit us to know something about law understood as the system that might apply to both divine and human societies? So when we draw the boundaries of law that broadly, we might wonder what we can take away from any conclusions that we reach. And so here is where I do intersect a bit with those critiques I mentioned at the beginning that other people have raised, Hima, Priel, Marmor. So some of the criticisms there have to do with the idea that, you know, beings like angels are far too removed from humans to be able to tell us anything of value about human law. And I do have some sympathy for that approach and that argument. And I think that Hart's approach has more value for us, given that it is tailored to human societies. I think it's difficult to imagine a situation in which it's valuable to know what law is like for angels or aliens. It seems to me more valuable to keep our theory directed towards human traits and the systems we find ourselves actually situated in. So fantastical thought experiments about creatures that are far removed from human beings, they might be able to tell us something, but I think we should be careful about what exactly they can tell us. So if they're used the way Hart does to illuminate the reality of the structures that we create in light of our common human traits, I think that provides some really valuable insight. But if they set out to tell us about the necessary features of law in all possible worlds, then I'm a little more skeptical. So perhaps thought experiments about angels are the right sort of thing to generate that information, but it's information that may have little value in understanding the real world in which we live. So that's I guess, a slightly skeptical point on which to end, but I'll leave it there, and I look forward to your questions. Thank you for listening.
Thank you very much, Professor, and I'm sure our participants will join me in thanking you for this very illuminating and exciting presentation. We'll stop now the recording and we'll move to the Q&A